The right to work is really important for employers. If an employer is found by the Home Office employing someone who doesn't have the right to work, the employer can face a civil penalty of up to £20,000, and in a worst case scenario they can go to prison. Also, for employers who hold sponsor licences, they can have their sponsor licence taken away. The best way an employer can protect themselves is by making sure they have a right to work document which evidences the person's immigration permission. That document will then be a complete defence against any subsequent charges that they have employed someone illegally. In terms of the right to work documents, there are some documents such as a British passport or a European passport that will be a permanent defence, and then there are other documents which will involve non-EU staff, which will either be a time-limited or a non-time limited defence. There are some staff members who will have permanent right to stay and you will have a non-time limited defence. For others, they will have a visa expiry and the document that they will give you will be a time limited document. Sometimes it can be straightforward, and other times establishing their right to work and keeping track of their visa can be complicated. We can help businesses in 4 ways essentially. Firstly, having the right to work is a question of law, so we can advise whether someone does in law have the right to work. We can also advise on whether or not right to work document is valid. We can provide extensive training to HR staff in terms of how to carry out a right to work check properly. And lastly, in a situation, for example, a to-pay situation, we can make sure there are no right to work issues that the new buyer of a company needs to be aware of.